So what I want to talk to you about this afternoon is the research I've been doing over the last year and a half on the Supreme Courts of Scotland. I was here from January through June of 2017 as a Fulbright scholar, and as part of that project, I collected data on the High Court of Justiciary, the criminal appeals in particular, and I am interested in the kinds of factors that might help us understand how the court makes those decisions. And I'm here now to study the inner house of the Court of Session, the civil side, and I'm in the data collection phase, so I won't be able to give you any data or analysis on the Court of Session, but I will tell you a bit about what I've been studying with justiciary. So again, my first focus last year was on the High Court of Justiciary acting in its appellate capacity in criminal cases. And by criminal cases, I mean both unpublished and published decisions. I petitioned the court for access to the unpublished decisions, and the Lord Justice General was incredibly open to scientific analysis of the court's work. Again, exhibited a level of transparency that certainly was notable and admirable, and I thank the Lord Justice General as well as the Lord Justice Clerk, who both met with me to talk with me about the court and facilitated this work. So what I have done so far is a statistical analysis of the 2015 decisions, as well as conducted interviews with the judges, and that's what I'll discuss this afternoon. The next stage of the project, which I'm currently in, as I said, is to look at the inner house and basically do the same sort of thing. And again, I'm a political scientist. So I'm interested in trying to understand if there are any factors we can identify beyond the law, if you will, in how judges make decisions. And I'll talk a bit more about that because it sounds illegitimate to suggest that that might be the case, and I'd like to be very clear about that. But I'm interested in two primary things. First of all, do we see any gender differences among the judges in the way they approach criminal appeals? And the answer to that is yes, and I'll show you some evidence to that. Now, we want to be very cautious about this because I can't reach any kind of conclusion about causation. We could be seeing these gender differences because of differences in the types of cases that are assigned to the panels, for example, or seniority, or things that are just coincidental to gender. So I'm not making any causal claims whatsoever here. I'm simply observing a pattern. And the second question gets to this idea of who wins, and political scientists love to talk about party capability theory. So when you have power asymmetries between litigants, have versus have-nots, who wins and why? And I'm interested in that. In criminal cases, you have an inherent power asymmetry. You have the power of the prosecution, the Crown, versus an individual. The Crown is much more experienced, has the authority of the state, is a regular repeat player in litigation. The individual typically is not, and thus is at a disadvantage. So what happens? Well, when we look around the world, we see lots of courts in which the have-nots consistently win for all sorts of reasons. So I'm interested in whether that's the case in Scotland and what might help to explain that beyond just the simple asymmetry. And what I found is that actually here, defendants win more often than not, and defendants at the appellate stage, not at the trial stage. Defendants win more often than not, so party capability theory doesn't seem to have that much explanatory power, and I'll talk about why that might be the case as well. But to get back to this question I posed first, why study judging? Well, judges are actually quite powerful people. Judges have a lot of authority over others, and in exercising that authority over others, they have discretion and have to use judgment. In doing so, individual judges shape the meaning of the law. I think that's certainly most obvious in common law when they're actually making the law, but that's true of constitutional and statutory law as well. And of course, they decide who prevails in litigation in very concrete circumstances, and all of those decisions have important impacts for individuals in society. And to bring it up to the level of the court, courts, of course, assign concrete meaning to the law. They also, through the aggregation of their decisions, affect the distribution of wealth and power in society. And they engage in representational politics and contribute to political legitimacy through the types of decisions they reach, their behavior on the bench, and even just by the composition of the bench. Does the bench look like the population they're serving? So courts are actually, and judges are incredibly powerful actors in the political system. We don't think of them as political actors, but by political I mean with the authority of the state. So what have we learned about judging across the world? Well, studies in political science have typically sought to understand how judges exercise discretion. We all understand that judges look at evidence and follow the law, and when the law is clear, judges follow the law. But what happens when the law isn't clear? And that's where political science engages, and what we're trying to figure out is what are those factors we can identify that might help judges decide cases systematically? What are those factors? And then what theories of human behavior can we then derive or begin with and then derive hypotheses from those theories? This approach challenges to some extent the normative ideal of the apolitical judge. I think it's certainly very comforting to think of judges as people who have no discretion, who simply read the law and apply it. Sort of mechanically, but the reality is simply not that in a proportion of the cases. And again, to repeat what I said a few minutes ago, there's nothing illegitimate about what I'm talking about or the way judges behave. Judges are often presented with cases where the law isn't clear, the facts aren't clear, and there isn't a way to definitively decide that case simply by looking at the law. There's nothing illegitimate about developing a judicial philosophy, about drawing on your own life experiences, whatever it is, your own religious beliefs, your own viewpoint of the role of society generally and so forth, in order to exercise that discretion. So what I'm describing in terms of the way judges behave shouldn't be construed as anything illegitimate. It's certainly not malfeasance. It's not bias in the way that we typically understand that. And I'd like to make that very clear before we proceed. So, first of all, my first question, are there gender differences in the High Court of Justiciary on criminal appeals? Well, if we look at the empirical work across the world, we get really all sorts of results. I'm not sure there are any consistent results at all. If we look inside the US, looking at state Supreme Courts, looking at the US Courts of Appeals, which are the two sets of courts most typically studied on this dimension, lots of times there are no gender differences whatsoever. When there are gender differences, it tends to be on issues that are typically associated with women's interests. So things like employment discrimination, abortion, capital punishment has been an issue where gender differences have been identified. And typically in those cases, women are more liberal than men, meaning women are more likely to support the claimant in a sex discrimination case, the abortion right. They're more likely to be against the power of the state in a capital punishment case. So there are some gender differences we've seen. Outside the US, there are some examples. For example, in the International Tribunal for the former Yugoslavia, there were gender differences in the way women judges sentenced. Women were more likely to give longer sentences to sexual assault cases when women were the victims, and men were likely to give longer sentences when men were the victims. So we found some gender differences there. And in the Supreme Court of Canada, as well as their intermediate appellate courts, we've discovered that women actually are more pro-prosecution in criminal cases than are their male counterparts. So they are more likely to find against the defendant, again, on average, than their male counterparts. So why does this happen? I'm not quite sure. I don't think we know certainly. Some people certainly claim they know why. Perhaps one of the most important foundations was Gillian's study of different voices. Gillian used developmental psychology to talk about differences in the development of women in society, and particularly the development of a more communal or community orientation versus an individual or perception of the self. And she would argue that it's really through developmental psychology that we understand these differences. But there are lots of other theories, competing theories, life experiences, as I said, different career paths for men and women, different selection processes that put them on the bench, philosophy coincidental to gender, the types of cases that might be assigned to the panels, again, coincidental to gender, and just the preferences of the panel majorities themselves. So there certainly isn't any consensus about why gender differences occur. We just know that we see them in some courts on some issues. Party capability theory, again, is this idea that some people just have intractable disadvantages in litigation. And to put it in the simplest, bluntest terms, people who are disadvantaged lose because their lawyers aren't as skilled as the lawyers who represent the haves. So Gallanter in 1974 wrote what became an intensely controversial set of articles about the United States. And what he found is that the have-nots, and he defined have-nots as individuals versus governments, businesses, associations, that have-nots are just inherently disadvantaged in the litigation process. And the primary disadvantage is they don't have the resources, they only do it once, as opposed to repeat players, and the lawyers that they hire, on average, are not as good. And so that caused Gallanter to say, this means that courts in the United States are falling a bit short of this normative ideal of equality and justice, that some, again, litigants are just simply inherently disadvantaged. A different way to say that, again, is that if you look at inherent resource disadvantages between litigants, the haves, which are governments, associations, businesses versus individuals, what we would expect, if Gallanter is correct, is for these haves to prevail much more so than the other litigants, the individuals. And again, it's better lawyers. So what have we found about this? Well, again, there's a lot more work on the haves, have-nots controversy than on the gender issue. And again, it's sort of a mess. Have-nots tend to lose, but it depends on a lot of things. It depends on the quality of counsel. It depends on whether have-nots attract amicus curiae support. It matters about specific issues. The salience of the issue can make a difference. and the preferences of the judges can make a difference. So it isn't a hard and fast rule. It's actually a fairly complicated process. So where do the haves win? The haves win in the US, they win in Canada, they win in Shanghai, and they win in Taiwan. Shanghai was studied at the trial level, actually. Didn't see any differences really, or not much to speak of, in South Africa, Israel, and Australia. And the have-nots actually win more often than not in state Supreme Courts if there's excellent access to legal counsel, high-quality legal services available, especially to indigents. And in the Philippine Supreme Court, the have-nots actually prevail more often than the haves. So all of this, and there are lots of theories about why this happens as well, but more and more political scientists and sociologists as well are looking around the world to examine, first of all, the behavior of judges in courts on this gender dimension, and then secondly, to look at the effects of courts in their societies from this perspective of haves, have-nots. So what have we discovered about party capability in the UK? Well, Hector was kind enough to point me in the direction of Professor Griffith, and I was delighted to read his work recently, and he had a rather different view of the Constitution and the judicial process here, and his assertions, from what I can tell on first reading, are entirely consistent with party capability theory, that the courts and laws are tilted toward those with property, and specifically the Conservative Party at the time he was writing. Bert Atkins, an American, looked at appeals decisions in the Court of Appeals for England and Wales in the 80s, actually, and he discovered that the haves win in that court, much more so than the have-nots. But Chris Henretti looked at the law lords over a significant period of time when there were law lords. He looked from the 1960s all the way through 2009 at the behavior of the law lords, and what he found is that it's a bit more complicated at that level, that in fact the government has a tremendous advantage over every other type of litigant. So the government wins, or won, with the law lords, but that no other type of litigant really had an advantage. So businesses and associations, for example, weren't any more advantaged than individuals in litigation, or disadvantaged. So in the UK, there's a mixed picture so far. So what might be different about Scotland? And this is where conversations have been really helpful with the Lord President, the Lord Justice Clerk, lots of people in Edinburgh Law School, lots of lawyers and so forth, and just the texts that are written about Scotland. What Chris Henretti certainly pointed out, and everyone else did as well, is that the quality of legal counsel in Scotland is exceptional. So especially in the UK generally, it's much harder to be a lawyer. The barriers for entry are much higher, and the quality of legal education is more consistent and quite high. So what we would expect is for criminal defendants at the appeals stage, again, I'm not talking about trials here, we're talking about the appeals stage, would have better access to lawyers than what you would find on average in the United States, for example, for criminal defendants, and that might make a difference. Another big difference is the judges' emphasis, and they said this over and over again, on consistency and fairness in sentencing. And that's manifested in all sorts of ways, but including, for example, the Scottish Criminal Cases Review Commission, this commission where one can go and raise issues about unfairness, and an independent commission will actually examine that case and potentially forward cases to the High Court of Justiciary. And then, of course, appeals are allowed here for all sorts of reasons they would never be allowed in the US. So, for example, one can appeal questions of fact here from criminal cases. Generally speaking, that wouldn't be allowed in the US. even minor cases. So someone's been sentenced to, 2 weeks in jail can be appealed here. That can't be appealed in the US. One can appeal on the basis of a sentence being excessively harsh. The flip side of that is the Crown can appeal because sentences are excessively lenient or unduly lenient. So we get a much wider range of opportunities to appeal here than you would see in the US and certainly Canada and a number of other nations. So Scotland might be a different type of case. Now, let's talk about some important features of the courts that should be taken into account as well. So first of all, panel size does vary, and you'll see that in the statistics that I show you. Typically, 2 judges sit when there's a sentencing appeal. 3 judges sit otherwise. So the size of the panels will vary. The chair of the court is the senior person on the panel, and that person usually writes for the court, but that's not a rigid rule. So people can volunteer. If they're a judge on a panel can volunteer. Someone who's an expert on the topic might be the person chosen rather than the senior member and so forth. But that's how opinions are written. The Lord Justice General and the Lord Justice Clerk tend to write in the most important cases, and that was something everyone discussed. There's a tendency to assign one of those 2 judges to cases that are the most important. Lots of decisions are issued from the bench. These are not published decisions typically, but there are statements recorded and revised after, and there is a written record of what was said. I will be analyzing those in the analysis, in the data that I show you. Those statements were made available to me thanks to the court and are part of what we're talking about. All of the 2015 decisions were unanimous. That's not an unusual tendency, but all of these were unanimous. And what that means is, statistically, that makes it virtually impossible to analyze individual judges voting, but we can look at the court. And again, appeals are taken to the UK Supreme Court only under unusual circumstances. There has to be a claim under the European Convention on Human Rights, or there has to be a devolution issue. Otherwise, the High Court of Justiciary has final authority in criminal matters in Scotland. And again, there have been studies, Chris Henretti, I'll talk about again. There is some evidence that theories of American judging won't work very well here. Chris analyzed the decisions of the law lords again, and he tried to do the sort of analysis that's very typical of the US Supreme Court, where we try to use the judges' votes, as we would call them in the cases, to try to order them in ideological space, and then use those scores to predict how they're going to vote. And we can do that very well and very accurately with the US Supreme Court. Chris tried to do that with the law lords, and it simply didn't work. So the sorts of attitudinal model, if you're familiar with that term, those types of studies don't appear to work readily here. At least they didn't with the law lords. Whether they do with the new UK Supreme Court remains to be seen, but I suspect Chris would be rather skeptical of that as well. So what did I do? So in terms of the research design, I first looked at all decisions decided by the High Court of Justiciary in 2015. That includes all unpublished decisions as well as those statements issued extemporaneously from the bench. There were a total of 284 of those decisions. I was able to use 278, or a very large, almost all of them actually, in the statistical analysis. So why couldn't I use them? Well, because I'm deriving the variables I'm using in the statistical models from the written statements themselves, and some of the written statements just didn't have enough information in them for for me to use, but 98% of them did, so that's pretty good. I'm going to be analyzing the court's decision as the unit of analysis. I can't use the individual judges' decisions because there's no dissent, and we wouldn't learn anything from that type of analysis. And what I'm interested in is who wins. Is it the accused in the appeal, or is it the Crown, the prosecution? So in the statistical analysis, that's a dichotomous dependent variable, win-lose. When the defendant wins, I coded that as a 1. When the Crown wins, I coded that as a 0. And winning in the standard way is defined as, is the accused any better off? So not necessarily did you win every argument you offered, or did you get a conviction overturned, just are you any better off? Was there any adjustment to the benefit of the defendant from the decision? It's a dichotomous dependent variable, so I'm using logistic regression to estimate the models, which is, again, very standard. So how are we going to measure gender effects? Well, I did it a variety of ways. The most straightforward way is to just look at the proportion of women on the panel. Does that make any difference in the probability that the case will be decided in favor of the accused? These are the proportions of cases that are decided and the number of women on the panels. So panel size varies from 0 to 3. And these are the various proportions. And you can see about 18% of the cases were decided with majority women panels. That's pretty good given what we see around the world. I also looked at whether there was a woman majority on the panel as an alternative to the proportion, and just to see if that was a valid measure. It seems to be. I coded whether a woman wrote the opinion to see if that would matter. And then I looked at the voting of women on an issue likely to be important to women, which is rape and sexual assault, again, based on what other studies have shown. And I used a statistical interaction term so that we can distinguish between the voting of male judges and the voting of male panels proportionally versus women judges and their votes on those cases. How do we measure party capability? Well, in general, criminal defendants are at a disadvantage, so that's just a constant in the models. But I also looked at whether a case was forwarded by the Scottish Criminal Cases Review Commission, and also whether the case is a Crown appeal, brought by the Crown. But again, keeping in mind that criminal defendants are considered inherently disadvantaged. So in that sense, it's a constant in the discussion. Other important factors, I think, would be whether the Lord Justice General or the Lord Justice Clerk is on the panel. That should be an indication that the issue is particularly important, and we might see that make a difference to the way the cases are resolved. I categorized the cases in terms of 4 categories, and we can talk about this because there are lots of other ways to do it, and I tried other options as well. But basically those sentence appeals, which we should expect to be decided more favorably to the defendant, I should think, than a conviction appeal, for example, or even pretrial issues. And there's a 4th category, sort of a miscellaneous, that include leaves to appeal, immigration, extradition cases. I estimated those separately. I dropped them from the analysis. I did all sorts of things to see if that made a difference. It actually really doesn't. And then specific crimes. We might expect murder cases, for example, which most people consider the most egregious in a society, to be less likely to be decided in favor of the accused. At the appellate level, these aren't trials. And then again, rape and sexual assault, so that we can examine the difference between women and men proportionally on panels on these issues. These are some statistics on just the means of the variables, just what's the average value. They're all zeros and ones, but the most interesting one is pro-defense. What that measures is the proportion of cases decided in favor of the defense. And you'll see that 54.3% of the cases are decided in favor of the accused in the High Court of Justiciary in appellate cases. That's not what we would expect if party capability has much explanatory power. So actually the accused win more often than not. So that raises some doubts about the ability of party capability theory to explain much in Scotland. Here are the statistical results from the first model that uses the proportion of women on the panel as the key variable. If you're not versed in statistics, that's fine. It doesn't matter. The important variable is the probability at the end that tells you the probability of a variable being associated with pro-defense claims versus just random chance. And what we can see is that the proportion of women on the panel actually does matter. As the proportion of women on an appeals panel increases, the pro-prosecution outcome increases. The probability of that increases. Women writing don't make any difference. The Lord Justice General or the Lord Justice Clerk writing does make a difference. Those are much less likely to be decided in favor of the accused, and that makes sense given the complexity and importance of the issues that they're deciding. The Crown appeals don't have any special weight. The Crown isn't more likely to win than anybody else in the court, so that also works against party capability theory. But commission referral is significant. And again, that's a power player, but it's a power player favoring the accused. So those referrals are more likely to produce a pro-defendant result. Sentence appeals are more likely to be pro-defendant, pretrial less, other issues less. Murder isn't significant. Rape and sexual assault for men by male panels isn't. And the interaction term for the proportion of rape and sexual assault and women isn't significant, meaning there's no difference between men and women in voting on those cases. So what we would derive from this, from the perspective of the issues I raised, is that in fact it does seem to matter who's sitting on the panel in terms of their gender. But again, I want to be very careful about that result because I can't assess why that is, and it could be coincidental to all sorts of other things. But we do see that pattern. But there's very little evidence of party capability. Here's a chart that shows predicted probabilities of a pro-defense result based on the gender composition of the panel. This is one of my favorite tools for understanding and explaining statistical results. And what this does is show you the probability of a decision being in favor of the defense as the proportion of women on the panel increases. At the 0 level, where there are no women on the panel, the probability of a pro-defense result is about 62%. When there's one woman on a 3-person panel, the probability is 0.5. When there's a 50-50 gender balance, it's about 50-50 of a pro-defense result. But when you have 2 of 3 women on a panel, the probability of the defense winning decreases to 4.7. And when it's an all-woman panel, it's 3.8. So it does, you're more likely to lose if you have a woman majority panel. Now again, I can't say why that is the case. So this is not judicial bias. Don't call it that. It just simply means that we need further investigation. Predicted probabilities of the commission go from 5.38, meaning it's about even. Again, that's the mean of the variable, so defendants are more likely to win anyway, even when there isn't a commission sponsor of the case. But when the commission sponsors, it goes to about 0.9. So almost not a certainty. There's still that 10% chance you're going to lose, but you're pretty likely to win. That's a pretty good bet if you can take that. If you have a 0.9 probability of winning, that's pretty good. And then here is, just to show you, if you're interested, a different way to measure gender effects. I measured it as a majority rather than the number, just is it a majority or not. That variable is still statistically significant. Nothing really changes in the model, so it's a stable result. And going from not having a majority of women to having a majority of women on the panel, again, reduces the probability from winning to losing, all things considered in the model. So what do I conclude? Well, gender dynamics may be operating in the high court in criminal cases. Why that is the case remains to be seen. But at least there's some evidence that gender might matter. The High Court in that regard is very similar to other high courts around the world, especially the Canadian Supreme Court and Canadian intermediate appellate courts, where women were in fact more conservative. That is to say, they were more likely to support the prosecution on average than their male colleagues. And what we might anticipate is that as the proportion of women increases in the judiciary in Scotland, you might see some interesting changes in important matters of law. As far as party capability theory, it's not very useful here. On balance, the accused wins more often than not. Crown appeals don't seem to carry any special weight in terms of the results. And the Scottish Criminal Cases Review Commission does tend to prevail. Not always, but wins the vast majority. Now, there were only a handful of these cases, so I want to be careful about that too. But based on what I was looking at, that certainly is the case. Why? I think it's because of the quality of legal counsel, which is significantly higher than what you would see across the board in a lot of the nations that have been studied, including and especially the US, as well as the judges' heavy emphasis on sentencing equity, which they emphasized. And then again, the High Court's decisions are consistent with these widely held normative expectations of equality in the litigation process, so I would think that would make at least the court and society quite happy. This idea of essentially legal system biased against the have-nots in this capacity doesn't seem to be the case in the UK, in Scotland anyway. And then finally, I think some aspects of the court's decisions here are amenable to quantitative analysis and theories of politics that are used around the world, even when we have unanimity among the judges. And what's next? The inner house of the Court of Session. I'm coding those cases now. I have the great pleasure of meeting with the Lord President and the Lord Justice Clerk in another couple of weeks, and which is extraordinarily gracious of them. I'm looking forward to that. And again, I need to really more carefully look at the causal elements of that relationship between gender and judging, and to test more directly the idea that the quality of legal counsel actually matters.